I'd say there's a majority of people that don't make this kind of money. We got to reflect the interests of the people here. With the benefits, this is a huge amount of money. I just think that we're not having a long line of people leaving these jobs, going to the private sector. Most of these people that have been in these jobs have stayed for years. I just don't feel that that's a problem. We've had several candidates running for these offices, so evidently they were satisfied with the pay. I just think we should not give these big raises.
Call for the question.
Ms. Bernard had her hand up for the second time.
Thank you, Mr. Chairman. Just one thing to point out also with the pensions. These 4 positions come with a defined benefit pension, which means they're going to be guaranteed something every month. Those of us who have 401ks are at the mercy of the stock market. These 4 individuals will be getting a guaranteed pension, and depending on the number of years, they're going to be looking at about probably between 60, possibly even 80% of their salaries, depending on when they signed in. So this is a very generous package that they have right now. In addition, look at their health care. Look at people in the private sector. They're seeing their deductibles go from $200 to $450 to $600 a person. And expensive stop losses and co-pays. So this is a really good package the way it is, and like I said, and perhaps I may not be as optimistic as others, but I really think this is a time where we buckle down and just maintain the course, stay the course.
Any other comments? Seeing none, we're voting on the amendment for 2% to 3%. We'll have a roll call vote on that. Yes means you want 2%, 3 means, or no means we want to go back to the original resolution.
Mr. Tripp?
No.
Mr. Washington?
Yes.
Mr. LaJess? No. Mr. Wood?
Yes.
Ms. Bernard?
Yes.
Mr. James?
Yes.
Mr. McLaren?
No.
Mr. Vickery?
No.
Mrs. Barber?
No.
Mr. Searchberger?
Yes.
Mr. Nicholas?
No.
Mr. Roltoff?
No.
Mr. Lear?
No.
Mr. Scholl?
No.
Mr. Hess?
Nay.
Mr. Foster?
No.
Mrs. Campbell?
Nay.
Mr. Pilecki?
Nay.
Mrs. McBride?
Yes.
Mr. Enns?
Yes.
Mr. Whitus?
Nay.
Mrs. Wilson?
Nay.
Mr. Tholen?
Nay.
Mr. Cruz?
Amendment fails 717, so we're back to the original resolution.
Roll call.
We'll have a roll call vote.
Mr. Tripp?
The original resolution.
Mr. Washington?
Aye.
Mr. LaJess?
Aye.
Mr. Whitten?
Aye.
Mr. Bernard?
Nay.
Mr. James?
Nay.
Mr. McLaren?
Nay.
Mr. Vickery?
Aye.
Mrs. Barber? Searchberger?
Nay.
Mr. Nicholas?
Aye.
Mr. Roltoff?
Aye.
Mr. Lear? Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mr. Foster?
Aye.
Mrs. Campbell?
Aye.
Mr. Pilecki?
Aye.
Mrs. McBride?
Nay.
Mr. Enns?
Nay.
Mr. Whitus?
Aye.
Mrs. Wilson?
Aye.
Mr. Tholen?
Present.
Mr. Cruz?
Aye. Motion passes 18-6. On item C.
Resolution of the County Board of Kankakee County, Illinois, the compensation for the coroner of Kankakee County, Illinois. Whereas in all counties of less than 2 million inhabitants, the compensation of coroners, county treasurers, county clerks, reporters, and auditors shall be fixed pursuant to 55 ILCS 5/4-6001. And whereas the Each officer in counties containing 100,000 or more inhabitants or less than 200,000 inhabitants, not less than $16,500 per annum, and to those officers beginning the terms of office on or after December 1st, 1993, base salary plus at least 5% base salary. There's an increase or decrease in the salary of an elected officer of any unit of local government shall not take effect during the term for which that officer is elected. Illinois Constitution Article 7, Section 9, whereas the term of office for the county coroner expires November 30, 2008, and the present annual salary of $57,915, whereas at the April 24, 2008 Finance Committee, after review and consideration, recommends that the salary for the county coroner be set as follows. December 1st, 2008, $60,811. December 1st, 2009, $63,852. December 1st, 2010, $67,045. December 1st, 2011, $70,397. Now therefore be it resolved by the County Board of Kankakee County that A, the salary for the Kankakee County coroner shall be fixed as follows between December 1st, 2008, $60,811. December 1st, 2009, $63,852. December 1st, 2010, $67,045. And December 1st, 2011, $70,397. These previous resolutions are portions of the conflict of setting the compensation for the coroner hereby repealed. This resolution shall be in full force and effect upon its adoption and passage. The committee recommends the adoption of this resolution here was submitted by Mr. Vickery, Mr. Foster, Mr. Blanky, Mr. Jeff, Mr. Weir, Mr. Show, Mr. Stopford, and Mr. Wilson.
Have a motion to approve. Made by Mr. Vickery, seconded by Mr. Hess. Any questions? Seeing none, we'll have a roll call
I
vote.
have my hand up, Mr. Chairman.
Ms. Bernard?
Thank you. You know, I did the math on this one, and the coroner stands to benefit by far the most of any of the 4 office holders. Over 4 years, you're looking at about a 23% raise. And I think at the very least, we should be consistent in the percentages that are going to be granted as increases. So I'm going to make an amendment to this motion that the percentage increase be at 3% consistent with the recorder and the auditor. That's my amendment.
There's an amendment to the motion to have the recorder be a 3% increase.
No, to have the coroner, yeah, I'm sorry.
Is there a second to the motion? Second by Mr. James. Questions or comments on the amendment?
Roll call, please.
We'll have a roll call vote. Yep, Mr. Roll call.
Mr. Vickery, speak to this.
Mr. Vickery.
Thank you, Mr. Chairman. Once again, this went through committee, been examined and talked about, but the coroner has done an outstanding job out there and has developed quite a coroner's office. And the people skills that Mr. Gessner has here are reflected in the many people that he has to deal with in tragic situations. And we must compensate the coroner for his efforts here. We did a study of all of the surrounding counties and other people here, and we have scaled this clear back. And I just think that after this thorough examination and looking at the job that Mr. Gessner has done, that the coroner's office, we need to compensate someone who does a great job for us. And once again, doing the people's business. The people have the opportunity to remove anybody from office when election comes. And so Mr. Gessner has done a great job here, and I think that we need to compensate him for his efforts and for the great job that we're getting out of the coroner's office in many, many facets, not to go into the whole thing. But anyway, thank you, Mr. Chairman.
Mr. James?
Thank you, Mr. Chairman. I don't disagree with any of that. There's a lot of people, we have a lot of good people doing it. What we're in, though, we're at an economic crisis, and I'm going to tell you right now, if we can't meet our bills, it really don't make a hoot what they're getting. And I think we should, as a prudent board, we should take a long, hard look at how we're handling the monies that we have to work with today and what we're going to have to work with tomorrow, whether or not we'll be able to meet some of these commitments we're putting out there before ourselves.
Mr. Altoff?
The reason I asked the question was, I guess in comparison with surrounding counties and counties our size, if we're keeping up. And I know if we don't maintain cost of living increases, then when we have to make a big jump, that's going to be very difficult. And I think we just need to keep up with the marketplace. And I think if anybody doesn't believe inflation is taking place, you're not living in this present age. So everything is increasing, and we need to stay up with the times.
Ms. Bernard?
Thank you, Mr. Chairman. It's interesting hearing the analogies about the marketplace being brought up here today. Number one, this is almost like monopoly pricing in a sense because there's no other person buying for this seat. Number two, we're talking about other counties and what they're doing. Well, Will County is not going to come in here and pay the salary. The people of Kankakee County are. So to use the other counties as comparison can be kind of disingenuous because, I mean, if the person's unhappy, then they can go to the next county and run for that position. If you know, there's the fallacy in that argument. And the other thing to look at, yes, inflation is happening, but why then a 5% raise for the coroner when a 3% raise suffices for the recorder of deeds and the auditor? So there's not even consistency in what's being said here. And fourth, these jobs, these 4 positions already pay well above the per capita, you know, the average household income in this county, or I'm sorry, the per capita average in this county of income. So as far as I'm concerned, we should just freeze these wages. I mean, if these people want to walk away from their jobs, they will, but I really highly doubt it.
Two things I'd like to throw in there about the coroner. First, I'd like to thank Mr. Gessner for the wonderful job he does. And second, the coroner's job is 24/7. He's on call at 3 a.m., he's on call at midnight, at 1 in the morning, plus then he keeps his normal office hours throughout the day. Second, if we're going to just say 3% across the board, that leaves us as supervisors or as managers absolutely no room to give a merit increase, which most employees get in their day-to-day jobs and their annual performance reviews. So, you know, maybe instead of giving 3%, we'll give 5% because, hey, you know, the coroner's office has received multiple commendations this year for the things they've done. Mr. Gessner's done an excellent job, and he stood out, you know, maybe above some of the other elected officials we have, and that gives us the room to give that kind of merit increase like most supervisors can give in their normal everyday jobs.
The motion is to amend the motion down to 3%, I believe. You've already talked on the...
No, once I talked.
No, you actually talked
about
it when you made the amendment, and then you also talked about it now.
So making the amendment is considered talking on it?
You betcha it is.
I'll check Robert's
Okay,
rules
so
on
we
that.
will vote on the amendment now. We'll have a roll call vote. Yes means you want to...
Mr. Chairman, point of order.
Yes.
While the county code may not allow for Mr. Tholen to vote, abstain or anything, I believe we can, and I would make the motion now to excuse him from voting since he hasn't been involved in any of these discussions at all until this time.
It's still up to him whether he wants to take on the question or not. So I'm leaving that up totally to Mr. Tholen.
Representing this taxpayers.
Okay. Yes vote means that you're going to decrease the salary even more. A no vote means it goes back to the original resolution. Okay? I have a roll call vote.
Mr. Trepp?
No.
Mr. Washington?
Nay.
Mr. Lejetz?
Yay.
Mr. Whitten?
Yes.
Mrs. Bernard?
Aye.
Mr. James?
Yes.
Mr. McLaren?
Nay.
Mr. Vickery?
Nay.
Mrs. Barber? Ms. Hertzberger?
Nay.
Mr. Nicholas?
Nay.
Mr. Olthoff?
Nay.
Mr. Lear?
Nay.
Mr. Scholl?
Nay.
Mr. Hess?
Nay.
Mr. Bossert?
Nay.
Mrs. Campbell?
Nay.
Mr. Galecki?
Nay.
Mrs. McBride?
Nay.
Mr. Inns?
Yes.
Mr. Whitus?
Nay.
Mrs. Wilson?
Nay.
Mr. Tholen? Nay. Mr. Cruz?
Nay. amendment fails 4-20. We're back to the original resolution now. We'll have a roll call vote.
Wait, I hold on.
Ms. Bernard?
Thank you, Mr. Chairman. I just want to point out that no matter how you feel about an individual, such as another board member said, this individual is doing a great job, we should have room to give him a 5% raise. Like Mr. James said, if we don't have the money, it doesn't matter.
And you know what, as an elected official, department head or whatever, they have to manage their budget with the money we give them. So that's still their job. So we're back to the original motion. We'll have a roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. LaJess?
Aye.
Mr. Whitten?
Nay.
Ms. Bernard?
Nay.
Mr. James?
Nay.
Claren?
Aye.
Mr. Vickery?
Aye.
Mr. Barber?
Aye.
Mr. Hertzberger?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl? Mr. Hess?
Aye.
Mr. Bossert?
Aye.
Mrs. Campbell?
Aye.
Mr. Kalecki?
Aye.
Mrs. McBride?
Aye.
Mr. Inns?
Nay.
Mr. Whitus?
Aye.
Mrs. Wilson?
Aye.
Mr. Tholen?
Present.
Mr. Cruz?
Aye. Motion carries 20-4. On to item D.
Resolution of the County Board of Kankakee County, Illinois, the compensation for the clerk of the circuit court of the 21st Judicial Circuit, Kankakee County, Illinois. Whereas in all counties of less than 2 million inhabitants, the compensation of coroners, county treasurers, county clerks, recorders, and auditors shall be fixed pursuant to 55 ILCS 5/4-6001. And whereas to each officer in counties containing 100,000 or more inhabitants but less than 200,000 inhabitants, not less than $16,500 per annum, and to those officers beginning a term of office on or after December 1st, 1993, base salary plus at least 5% of base salary. Whereas an increase or decrease in the salary of an elected officer or unit of local government shall not take effect during the term for that officer, which is elected under the Illinois Constitution, Article 7, Section 9. Whereas the term of office for the clerk of the circuit court, 21st Judicial Circuit, Kankakee County, Illinois, expires November 30, 2008. The present salary is $61,193. Whereas at the April 24, 2008 Finance meeting, after review and consideration, recommends the salary for the circuit clerk be set as follows: December 1st, 2008, $64,253. December 1st, 2009, $67,466. December 1st, 2010, $70,839. December 1st, 2011, $74,381. Now therefore be resolved by the County Board of Kankakee County that the salary of the Kankakee County Circuit Clerk shall be fixed as follows: beginning December 1st, 2008, $64,253. December 1st, 2009, $67,466. December 1st, 2010, $70,839. December 1st, 2011, $74,381. Any previous resolutions or portions of conflict with such compensation, the clerk of the circuit court of the 21st Judicial Circuit is hereby repealed. This resolution shall be in full force effect upon its adoption and passed. May recommend the adoption. This resolution here was submitted by Mr. Vickery, Mr. Prosper, Mr. Fleck, Mr. LaJess, Mr. Lear, Mr. Scholl, Mr. Stroudsburg, Ms. Wilson.
I have a motion to accept made by Mr. Scholl, seconded by Mr. Vickery. Any questions? Roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. LaJess?
Aye.
Mr. Whitten?
Nay.
Mrs. Bernard?
Nay.
Mr. James?
Nay.
Mr. McLaren?
Aye.
Mr. Vickery?
Aye.
Mrs. Barber? Mr. Hertzberger?
Nay.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mr. Bossert? Mr. Bossert?
Aye.
Ms. Campbell?
Aye.
Mr. Kalecki?
Aye.
Ms. McBride?
Aye.
Mr. Inns?
Nay.
Mr. Whitus?
Aye.
Mrs. Wilson?
Aye.
Mr. Tholen? Cruz?
Motion carried 19-5. Item E.
Resolution of the County Board of Kankakee County, Illinois, the compensation for the auditor of Kankakee County, Illinois. Whereas in all counties of less than 2 million inhabitants, the compensation for coroner, county treasurer, county clerk, recorder, and auditor shall be fixed for 255 hours a year, 5/4 Act 5001. Whereas each officer in counties containing 100,000 more inhabitants and less than 200,000 inhabitants, not less than $16,500 per annum for those officers beginning the term on or after December 1st, 1993, base salary plus 3% of base salary. Whereas an increase or decrease in the salary of an elected officer of any unit of law enforcement shall not take effect during the term for which that officer is elected. Only Constitution Article 7, Section 9. Whereas the term of office for the county auditor starting November 30th, 2008, the present annual salary of $56,722. And whereas at the April 24, 2008 Finance Committee, after review and consideration, recommends the salary of the county auditor to be set as follows. December 1st, 2008, $59,652. December 1st, 2009, $61,442. December 1st, 2010, $63,285. December 1st, 2011, $65,187. Now therefore be resolved by the County Board of Kankakee County that the salary for the Kankakee County auditor shall be fixed as follows. December 1st, 2008, $59,652. December 1st, 2009, $61,442. December 1st, 2010, $63,285. December 1st, 2011, $65,184. Any previous resolution or proportional conflict with such compensation on the auditor shall be repealed. The resolution shall be full force and effect upon its passage. The committee recommends the adoption of this resolution. Mr. Hickory, Mr. Foster, Mr. Flecky, Mr. Jeff, Mr. Rear, Mr. Schultz, Mr. Stomberg, resolution.
I have a motion to approve. By Mr. Hickory, seconded by Mr. Bosser. Questions? We have a roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Jess? Aye. Mr. Whitten?
Aye.
Mrs. Bernard?
Nay.
Mr. James?
Yay.
Mr. Clarence?
Aye.
Mr. Hickory?
Aye.
Barber? Richburger?
Nay.
Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear? Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mr. Foster?
Aye.
Mrs. Campbell?
Nay.
Mr. Flecky?
Aye.
Mr. McBride?
Aye.
Mr. Innes?
Nay.
Mr. Whitus?
Aye.
Mrs. Wilson?
Aye.
Mr. Follen?
Present.
Mr. Cruz?
Aye. Carries 19-5. Item F.
Resolution of the County Board of Kankakee County, Illinois, increased per diem for county board members. Whereas the county board last made adjustments in per diem in April 13, 2004 for certain members of the county board. Whereas the county's code provides that if the county board desires for the next reapportionment to change the basis of payment, the amount of compensation after fixing those terms, they may do so by ordinance or by resolution. The changes shall not however take effect in the term for which the county board member is elected. Whereas the terms for County Board Districts 1, 3, 5, 7, 9, 11, 13, 15, 17, 19, 21, 23, 25, 27 shall commence December 1st, 2008. Whereas presently the per diem rate is $66, and whereas at the April 24, 2008 Finance Committee meeting, after review and consideration, the Finance Committee recommends that the rate per diem be set as follows for the odd numbered districts. Beginning December 1st, 2008 per diem, $68. December 1st, 2009 per diem, $70. December 1st, 2010, $72. And December 1st, 2011 per diem, $74. Now therefore be resolved that the County Board member of Kankakee County shall set the per diem rate as following for the odd number districts. Beginning December 1st, 2008 per diem, $68. December 1st, 2009 per diem, $70. December 1st, 2010, $72. December 1st, 2011, $74. Now therefore be it any and all previous resolutions proportionally here within the country that this resolution grants per diem for odd number districts shall be repealed, and this resolution shall be in full force effect when it's adopted. The committee recommends the adoption of this resolution with Mr. Vickery, Mr. Foster, Mr. Flecky, Mr. Jeff, Mr. Lear, Mr. Scholl, Mr. Stopberg, and Mr. Wilson.
Do I have a motion to approve? Made by Mr. Vickery, seconded by Mr. Lear. Any questions? none, roll call vote.
Mr. Tripp?
Nay.
Mr. Washington?
Aye.
Mr. Legess?
Aye.
Mr. Witt?
Nay.
Mrs. Bernard?
Nay.
Mr. James?
Nay.
Mr. McLaren?
Aye.
Mr. Vickery?
Aye.
Mrs. Barber?
Aye.
Mr. Hertzberger?
Nay.
Mr. Nicholas?
Aye.
Mr. Olthoff? Mr. Lear?
Aye.
Mr. Scholl?
Nay.
Mr. Hess?
Aye.
Mrs. Bossert?
Aye.
Mrs. Campbell?
Nay.
Mr. Colecki?
Aye.
Mrs. McBride?
Nay.
Mr. Enns?
Nay.
Mr. Whitus? Mrs. Wilson?
Aye.
Mr. Tholen? Present. Mr. Cruz?
Motion carries 13 to 11. This is for the salaries. I can tell you this, but good luck in 2 years because I won't have to be doing this. Okay, on PZA, May.
Resolution of the County Board of Kankakee County, Illinois. The authority to hire the consulting firm Crawford, Murphy, and Tilley Incorporated for the Airport Study Task Force project. Whereas on January 23rd, 2008, the Metropolitan Planning Organization, MPO, they recommended the implementation of the Airport Study Task Force. Whereas three governmental units, the City of Kankakee County, and the Kankakee Valley Airport Authority, have formed a task force to initiate planning studies in the areas of airport development, land use planning, transportation planning, and economic development for the areas surrounding the greater Kankakee Airport, will be collectively known as the Airport Study Task Force project, which Kankakee County will manage. Whereas the Airport Study Task Force interviewed three separate consulting firms on Monday, April 2008. The recommendation was given to the PTA committee to retain the firm of Crawford, Murphy, and Tilley Incorporated to consult for the study and recommendations accepted by the PTA. The consulting firm of Crawford, Murphy, Tilley Incorporated will perform certain services required by Kankakee County on a task order basis, and whereas the county and the airport authority will each contribute $5,000 for the consultant's fee, and the city will contribute $20,000 for the consultant's fee, and the balance of $20,000 will be paid out of Illinois Assistance Grant Fund. The county board chairman is hereby authorized to execute the contract between Kankakee County and Crawford, Murphy, and Tilley Incorporated consultant services for the airport study. The contract is substantially forms as attached here to as Exhibit A. Now therefore be it resolved by the Kankakee County Board review, discussion, and consideration of the county board chairman is hereby authorized to render consulting for Crawford, Murphy, and Tilley Incorporated for an airport study. The committee recommends the adoption of this resolution. Here was submitted from Mr. Olthoff, Mr. Stopberg, Mr. Hertzberger, Mr. James, Mr. Bride, Mr. Marcotte, Mr. Joe, Mr. Washington, Mr. Whit.
I have a motion to approve by Mr. Olthoff, seconded by Mr. Washington. Are there any questions on this? Seeing none, we'll have a roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Legess? Present.
No, you're not.
He goes,
I vote yes. I'm getting so confused on all these presents and abstaining, but I do vote aye.
You understand? You're really good.
Mr. Witt?
Aye.
Mr. Bernard?
Aye.
Mr. James? Mr. McLaren? Mr. Vickery?
Aye.
Mr. Barber? Mr. Hertzberger.
Aye.
Mr. Nicholas.
Aye.
Mr. Olthoff.
Aye.
Mr. Lear.
Aye.
Mr. Scholl.
Aye.
Mr. Hess.
Aye.
Mr. Foster.
Aye.
Mr. Campbell.
Aye.
Mr. Pilecki.
Aye.
Mr. Bride.
Aye.
Mr. Yates. Mr. Innes.
Aye.
Mr. Whitus.
Aye.
Mrs. Wilson.
Aye.
Mr. Tholen.
Aye.
Mr. Cruz.
Aye. Motion carries. Under old business, we had recent appellate court decision on Town and Country. Many of you have read about it or heard about it. They reversed their decision that was rendered quite a while back. We have Mr. Helston here, been our outside attorney, who's been helping with this process. I would turn it over to Mr. Boyd with the State's Attorney's Office and Mr. Helston for an update and what's happened and where we need to go.
Chuck, why don't you both come on up? For those of you who don't know, the gentleman at the microphone is Mr. Helston. He's our outside counsel. And Chuck, the gentleman with you is?
Steve Swafford, who's head of our appellate division.
I've asked Ed to come and speak to you today with regard to the current status of the litigation involving the proposed Town and Country landfill. As Mr. Chairman Cruz has advised you, the appellate court has reversed its previous ruling. As a result of that, certain actions have been taken in an interest to protect the county's interest until such time as the county board could meet. This was the next meeting of the county board, and I'm going to turn it over to Mr. Helston to explain to you what the current status is, and you can ask him appropriate questions.
Okay, thank you, Mr. State's Attorney. It's good to see you all and miss some of the familiar faces that aren't here anymore. Just to give you a little bit of a recap, this is the second application. This pertains to the second application that was filed by Town and Country with the city. As you may recall, by almost unanimous vote. I'm sorry. At that, as you may recall, after that citing approval by almost a unanimous vote of this county board, we were directed to appeal the granting of citing approval on the second application, which we did. We were successful before the 3rd District initially. November 17, 2006, the 3rd District entered an order saying that the citing granted in the second hearing was invalid because there had been a disapproval, although it was a disapproval by the Pollution Control Board. No, I'm sorry. What they said is, they said there had been a disapproval. So then, there could not be a second application filed within 2 years, which is substantially similar. The court found, looking at the facts, that the two applications, as we had argued, were substantially similar. Therefore, the second application was invalid because it had been filed within 2 years. Almost immediately thereafter, the applicant, Town and Country, filed a petition for rehearing, which essentially says, oh, wait a minute, you have to give deference to the findings of fact of the decision maker if there's any basis to uphold them. And while you may not agree with what the decision maker did, there is some basis for their opinion. That petition was filed, and we've, the last 14, 15, 16 months, time flies when you're having fun, ensued, and on April 24th, a couple of weeks ago, we received it, within the last several weeks, we received a decision from the 3rd Appellate District saying, well, we're reversing ourselves. we previously held for the county and held factually that these were substantially similar, but we are now adopting the findings of the Pollution Control Board that these were not substantially similar. The problem with that decision is the Pollution Control Board never made that ruling. The Pollution Control Board based their decision upon the denial issue. What the Pollution Control Board said is, well, there was never a denial by the city of Kankakee, the decision maker. We think the reference to disapproval or denial refers to the initial decision maker, so the 2 years never started. So they didn't ever make a finding that the two applications were not substantially similar. That being the case, of course, we consulted immediately with the state's attorney's office, and the state's attorney, as he had indicated, and we had some time-critical decisions to make, simply as your state's attorney said, to preserve your rights and maximize the possibility that your position will be heard by the Supreme Court. And under some rather trying times of the last week, the state's attorney said, do what you need to do to maximize the rights and preserve the rights of the county, which we did. Procedurally, what we have done, and Mr. Swafford, I don't know if you want to take over, what we have done is filed a motion for a supervisory order with the Illinois Supreme Court. In essence, what that motion says is there are some inconsistencies in the ruling of the 3rd Appellate District. Given the nature of this case in general and the fact that the first appeal went all the way to the Supreme Court and was reversed in favor of the county, you should look at this immediately. You should vacate the order of April 24th by the Court of Appeals so that our time period for filing a petition before the Supreme Court doesn't run. That if they vacate that order, then there's nothing to appeal. The other issue is when the applicant filed their petition for rehearing, we filed a response saying, well, justices of the 3rd District, we don't think you should grant their petition for rehearing on the substantially similar issue. But if you do, bear in mind, we have raised 5 or 6 other material grounds that we think justify denial of the second citing application. Rule on those. Well, those were not ruled on. What we've asked for in the motion for supervisory order is that the Supreme Court direct the 3rd District to rule on those alternative grounds as well. We are not sure, of course, whether or not the Supreme Court will rule on our motion for supervisory order by the time period that we would have had to file our appeal to the Supreme Court, which would have been April 29th. So in order to run a dual track and protect all avenues, we've also filed a motion for leave to extend the time period for filing our petition for leave to appeal. Mr. Swafford?
I'm not sure you did. I don't really think you missed anything. Basically, the supervisory order, the purpose of it is to try to get the Supreme Court to direct the appellate court to decide all the issues that it failed to decide the second time it decided the case against the county.
Okay. So we'll open it up for questions and discussion. Mr. Olthoff?
Is it correct that we're trying to get this heard before they go into the summer when we're not in session?
Yeah, the Supreme Court only meets every other month, and it doesn't meet in the summer at all. And it's in session starting yesterday, I believe, through the end of next week. And so, yeah, a big reason behind filing the motion for supervisory order almost immediately was to get it before the Supreme Court when it was in Springfield and could expeditiously rule on that motion for supervisory order and discuss it. Because otherwise, if the court's not in session and you file one of these motions for supervisory order, it gets passed all around the state, and you don't know when you're going to get a decision, and you don't get the conference of the 7 judges.
Other questions? Mr. Meyer?
I guess one question I would have is how long are they on recess for the first of summer? Do they go back?
The court's just going through the 23rd, I believe, of this month, and then it doesn't come back in session until, in Springfield, until September sometime. It's not like they don't do any business at all, but, because they do business, but they're doing it from, 5 different offices around the state, and they're on vacations and whatever. Things move slowly. They do business over the summer, though.
Mr. Ransom?
Yeah, if this isn't heard this month, does that mean that the permit will be issued?
There is a IEPA permit that was received on, I think, the 3rd try by Town and Country. There was an IEPA permit issued when they had, for that period that they had siting approval before the 3rd District reversed initially. Of course, once the 3rd District reversed, then the issue becomes, well, is that permit now void, or was that permit simply dormant? Of course, I would imagine the applicant would take the position, well, that permit was only dormant, since now the siting has been reinstated some 4 years later. But there is a permit that has been issued by IEPA to develop the facility. I believe, again, it was either on the 2nd or 3rd application. Again, the county took a hard look at the first 2 applications, filed its comments with IEPA, and the first several times there were multiple denial points by IEPA on the permit, but I believe it was the 3rd time. I might be wrong, it might have been the 2nd, but I believe on the 3rd application a permit was granted, after all the issues that were raised in the first 2 applications were presumably addressed.
One other thing, if this does go before the Supreme Court, can some of these other grounds be brought up, or will it only be on the issue that the appellate court considered?
We preserved all these issues so that they would all go to the Supreme Court. Let me back up a minute. I just want to make sure it is understood right now. The only thing we really have on file is the motion for supervisory order, which we direct the appellate board to decide all these issues. And we haven't filed a petition for leave to appeal yet. We haven't had that direction yet to actually petition for leave to appeal to the Supreme Court. If we did, all the issues would go up.
Other questions? Ms. Bernard?
Thank you, Mr. Chairman. By taking the course of action you're taking now and not filing that appeal yet, that doesn't endanger our ability to appeal, does it?
By filing motion for supervisory order, no, we can still file a petition for leave to appeal. We just thought that this was the most expeditious way maybe to get a decision on all the points by the appellate court, because again, with this problem of the Supreme Court not meeting in the summer, we filed a petition for leave to appeal, which would originally be due on May 29th, although we have asked, we can get one extension, and we are getting that. They're not going to rule on any petition for leave to appeal as to whether to even take the entire case until the end of September. So we're going months and months and months where the court is not going to rule on any petition for leave to appeal that we would file.
Also, just to add, Ms. Bernard, as I understand it, Mr. Swafford can elaborate if he chooses to do so. As I understand it, the idea behind filing the motion for supervisory order is if the Supreme Court grants that and vacates the April 24th order of the 3rd District, then the issue of having to appeal becomes moot.
Mr. Washington?
Then would we be in order here today by directing you to appeal if that is not granted, so that we're not wasting time coming back here and asking us again?
What I would ask for the board is first to give approval to the action we've already taken, which is the filing of the request for a supervisory order from the 3rd District. Then, whatever this board's desire is with regard to seeking a petition for leave to appeal, you may discuss and make those motions. And if for some reason this board does not wish to go forward with the petition for supervisory order, today is the day to direct us in that fashion as well. I advised Mr. Helston when I met with him, without the board present, obviously, in the short time we had, that all the actions we were taking between the time that the appeal order came down and today's date were subject to being thrown out the window if the county board chose to take some other course of action. So it is, that's what we're here for. Do you want to continue going forward on the course that's been described by Mr. Helston? And in the event that the supervisory order is denied, are you interested in going forward with a petition for leave to appeal to the Supreme Court? Those are the questions before you.
First of all, I make the motion to approve the supervisory action that's been taken.
And there's a motion on the floor by Mr. Washington, seconded by Mr. Scholl, I believe, first. Okay. And this is for to continue the course of the supervisory action.
Yes.
Is there any questions or comments on this, Mr. Rotop?
Could you speak to the way the appellate court will receive this supervisory order?
No judges, I don't believe any, but this is speculative. No judges like the reversed, or the, I'm sure, but it's all part of the judicial process with any case, and I don't think it's anything out of the ordinary, even though it's called sometimes extraordinary. But it's just a normal appellate process, and I think that, well, I mean, the appellate court's ruled two different ways so far, so it's shown a willingness to comply with the law, so I assume it will take any direction it gets from the Supreme Court appropriately and decide the balance of the issues on the merits, we hope.
If you had to give us a percentage of success on the first item,
I really can't
pushing us to the
give
second.
a percentage. All I can say is that the case, or part of the case, has been in the Supreme Court once, so I would assume they would give it very serious consideration. So.
Other comments, questions? Mr. Bosser?
Do we have a partner on this? Is Waste Management participating, or what is that status?
No, at this point in time, we do not. It was some, initially some 3, 4, 5 years ago, Waste Management agreed to reimburse the county for the portion of its efforts going forward that pertained to defending the county's plan, the integrity of the county's solid waste plan. Since then, Waste Management has elected not to participate any further in that process, so it would be the county going forward at its own expense.
Mr. Renth?
What would be the time frame for you to get an answer on this? Because I think time is probably of essence, because early next year we may have a new mayor and this may be all approved.
There's so many different things that can happen from this point on. I mean, with regard to the supervisory order, which would just, if we got it, and would open up the appellate court's judgment again, the supervisory order will come down relatively quickly, okay, within the next few weeks. If it opens up, if it directs the appellate court to reconsider, if it vacates the April 24th judgment, the appellate court took 17 months on the last petition for rehearing, so it could take, it's going to take months and months again. I wouldn't expect anything at the earliest until well into the fall or next winter, and perhaps way beyond. But that was one of the contingencies. I mean, there's, you know, various others. We filed a petition for leave to appeal, and were granted in September. You know, that's another year's worth of litigation.
Any other questions or comments? Okay, we have a motion on the floor to continue on with the supervisory order. It's going to, we have to have a roll call vote.
Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Lejess?
Aye.
Mr. Whitten?
Aye.
Mrs. Bernard?
Aye.
Mr. James?
Aye.
Mr. McLaren?
Aye.
Mr. Vickery?
Aye.
Mrs. Barber? Mrs. Hirschberger?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mr. Bosser?
Aye.
Mrs. Campbell?
Nay.
Mr. Pilecki?
Aye.
Mr. McBride?
Aye.
Mr. Vance?
Aye.
Mr. Weddis?
Aye.
Mr. Wilson?
Aye.
Mr. Tholen?
Aye.
Mr. Cruz?
Motion carries 23-1. Now, we would have, if there's a motion for the direct to appeal, should that need to be going on. Made by Mr. Nicholas, seconded by Mr. Lejess. Discussions on that. Mr. Olthoff.
Could we get a rough estimate of what the first procedure would cost and then what the second procedure would cost?
The first procedure, you mean the supervisory order? I'm going to this is very rough because I didn't prepare it. The partner who prepared this is in an appellate court in an oral argument today, which is why it came down. She only spent a day or so on it, so it didn't cost anything huge. A petition for leave to appeal is going to take a week's worth of time anyway, perhaps more.
What I was told, because this was a question that was asked of me by your county administration and your state's attorney, which I in turn asked to Nancy Lisher, who is another senior partner in the appellate department who did the motion. She said, I recently had another case where the record was 8,000 pages. She said, I need to see the record here. My associate went down to the 3rd District to get the record, to secure the record. It's more than 8,000 pages, but I lived through this. I've lived through this, so I can help focus the appellate department on just the relevant portions of it. But in that case, she said we had 8,000 pages of record to go through. We had 2 briefs, which you do in a matter like this, an oral argument, and that was a total of 250 hours. Times an appellate rated $250 per hour. I think that works out, because I knew this question was coming up, to $62,500. There'll probably be some work by me, maybe 30, 40 hours worth of work, which may reduce, Mr. Althoff, the time on the other end. Hopefully it would reduce the time on the other end. So I think you're looking at probably anywhere from $65,000 to $75,000, $80,000 at the end of the day.
Yes. When you have the first procedure where you've got the supervisory order, are you heard before the appellate court again? You have to present your case or not?
It is discretionary with the appellate court. I would be really guessing to see what they did. They didn't rehear argument on the petition for rehearing filed by Town and Country. So perhaps this time they might. I don't know.
Are there any other questions? Seeing none, we'll have a roll call vote on the motion then to move forward with the appeal.
Mr. Tripp? Aye. Mr. Washington?
Aye.
Mr. Lejess?
Aye.
Mr. Whitten?
Aye.
Mrs. Bernard?
Aye.
Mr. James?
Aye.
Mr. McLaren?
Nay.